Namaskar, brothers and sisters, ladies and gentlemen, students and scholars, teachers and trainers, professors, professionals, officers, officials, listeners, learners. I thank all listeners and learners. I welcome respected doctors and directors. I welcome all honorable ministers and managers. I welcome honorable advocates, advertisers, administrators, and advisors. I welcome the most honorable President Professor Mukherjee. It is really nice time, nice place, nice section today. We are explaining, describing our holy Indian Constitution, judicial process. The principles of interpretation guides the justices in adjudication upon up to what extent this statement is true. Thus explaining the interpretation has an important place in adjudication. Many times such cases are put before the court where in the used words are not clear or suspicious, having more than one meaning, not in use, giving contradictory meaning, or not giving the meaning according to the intention of statutes. Under these circumstances, these are interpreted by the courts and a clear meaning is given to them. What is interpretation? According to Maxwell, interpretation of statutes, the process of determining the meaning of language and expression of statutes by the court is called interpretation. The determination of meaning of entanglement of words and expressions used in statutes is done by the courts through interpretation. According to Professor Gray, interpretation is such a process by which the courts determine meaning of words used in written law according to intention of statutes. According to Maxwell, the object of all interpretation of a statute is to determine what intention is conveyed either expressly or impliedly by the language used, so far as is necessary for determining whether the particular case or state of facts presented in the interpreter falls within it. Maxwell interpretation of statutes in the case of Shri Jairam Educational Trust versus A.G. Saidi Muhammad EIR 2010 SC 621. It has been held by the Supreme Court that it is not the object of interpretation, that it is to be seen that whether the law is according to courts of justice or not, but the object is that whether the intention of statute is fulfilling or not. Rules of interpretation, mainly the interpretation of statutes is considered of two types. One is literal interpretation and two is logical interpretation. What is literal interpretation? Literal interpretation is also called the grammatical interpretation. In reference to interpretation, the literal interpretation has an important place. It is considered as the best rule of interpretation. According to it, the meaning of the words used in statute is given according to them. If the language and word are clear and unsuspicious, this is a fundamental principle of interpretation of statute, that where the language of statute is clear and unsuspicious, there the meaning should be given according to it. Proof for versus sponsor for AIA 179, Kailash Chandra versus B. Kishan AIR 1998, Rajasthan 134. In the case of MS Kailash Roy versus Commissioner Kalgaon Development Authority, AIR 1995, Karnataka 44, it has been held by the Karnataka High Court that if the language of statute is clear and unsuspicious, then the meaning should be given according to it. In the case of Swedish match AV versus Security and Exchange Board India Area 2004 SC 4219, it has been propounded by the Supreme Court that where the language of statute is clear, there it should be interpreted literally and not otherwise. In the case of Balapur Industries Limited versus Union of India AIR 1997, Delhi 1, and Satyanarayan Das versus Government of India AIR 1995, Odisha 253, also the Delhi and Odisha High Court respectively have expressed the views. To know the intention of statute, it is the best rule. It is also called litera legish or litera script. This question of interpretation arises when the language used in the statute is suspicious. When the language used in the statute is suspicious or giving more than one meaning, Prakash Gupta versus Digvijendra Pal Gupta AIR 1982 SC 1213. In the case of Manita Khurana versus Indra Khurana AIR 2010, Delhi 69, It has been stated by the Delhi High Court that no absurdity or ambiguity in the language when constructed literally. No need for adopting rule of purposive construction. In the case of B. Permanent versus Mohan Koikal EIR 2011 SC 1925, it has been propounded by the Supreme Court that literal rule of interpretation would apply when language of statutory provision is plain and clear. Logical interpretation. The second rule of interpretation is logical interpretation. Logical interpretation is required when literal interpretation is not working, that is giving unwanted or inconsistent results. When the language of a statute is unable to give a clear and one meaning, then the efforts are made to know the intention of statute by deeply going through the statute under the logical interpretation. It is also called sentential legis. It is based on the prudence. In the case of Madan Valley versus Balu Padmana AIR 1916, Mahsoor 299, it has been decided by the Mahsoor High Court that it is universal rule of interpretation of statutes that meaning of the words to take should be take grammatical meaning at the time of interpretation. It is not the working of word of deriving the meaning that there may be some other intention of the statute. If the meaning of word is clear and unsuspicious, then there is no need of interpretation. The question of interpretation arises only when the language used in the statute is suspicious or giving more than one meaning. In the case of S. Samuel versus Union of India AIR 2004, SC 218, it has been stated by the Supreme Court that two things should be taken care at the time of interpretation. One is nominal meaning should be taken for the nominal words, and two is in case of the words having more than one meaning, such meaning should be selected which appear appropriate in that reference. There are the golden rule of interpretation. Golden rule has an important place in the interpretation of the statutes. And we have seen above that while interpreting the statutes only its wording, meaning should be accepted. But if the language used in the statute is ambiguous, then the meaning may be taken according to the intention of statute after making some improvements. This is called the golden rule of interpretation. According to Maxwell interpretation of statutes, the golden rule of interpretation is this, that in first instance the words of statute should be accepted in their normal meanings. In interpretation of statutes, its worldly expression should be considered an abstract concept to be real up to that time if the use of that words is not done in a special meaning or in different meaning from all meaning of that. In the case of Balapur Industries Limited versus Union of India AIR 1997, Delhi 1, it has been determined by the Delhi High Court that for providing real form to intention of intention of legislation, firstly the language used in the statute should be interpreted wordly or grammatically. But when difficulty is being felt in doing this, then to remove that, the situations prevailing at the time of meeting status may be considered. This is the golden rule of interpretation. In the case of Directorate of Enforcement versus Deepak Mahajan EIR 1995 SC 1775, it has been propounded by the Supreme Court that the golden rule of interpretation is this, that intention of legislature may not become insignificant. To find out the intention of legislature and for implementation of objective of statute, if the court has to go beyond wordly or grammatical interpretation, then it can be done. What are the rules of mischief? There is no place of mischief in interpretation of statutes. It is expected that the interpretation of statutes should be made in such manner so that mischief may not get any place. According to Maxwell interpretation of statutes, at the time of interpreting statutes, the courts should take care that mischief may not get any place in them. In the case of Kadurang Duplu Paste versus Lamchandar Bavaru Hardware EIR 1997 Bombay 397, it has been held by the Bombay High Court that it is better that interpretation of statutes should be done wordly and grammatically so that mischief may not get any place in them. It is only an interpretation by which the aim of statutes can be achieved. In the case of Eden 1854 3 CR 7, this subject is well explained. Those four elements are mentioned in which it are required to be taken care at the time of interpretation. What was general law prior to passing the existing act? What was that mischief or default for which no remedy was available in general law? Which remedies were suggested by the Parliament to remove drawbacks of Commonwealth? What was the actual reason of remedies? In the case of Rajavrat Mehta versus Amarendu Banerjee, AIR 1997 Patna 114, and T. Kumar Balkrishnan Roya versus A.K. Menon, AIR 1997 SC 442. It has been held that where a word is suspicious of giving more than one meaning, there such meaning should be accepted, which is making the objective of statute useful and redressing to mischief. In the sense, rules of interpretation are as under. One is, if the language of statute is clear and unsuspicious, then the meaning should be given according to it. MS Kalasroy versus Commissioner Bogana Development Authority IR 1995 Karnataka 44, as far as possible, wordly and actual meaning of the words should be accepted. Satyanarayan Das versus Government of India EIR 1995 Odisha 253. Meanings to the words should be given in the same way in which reference they are used. Regional Executive Kerala Fishermen Welfare Fund Board versus Messrs. Fancy Food AIR 1995 SC 1620. The intention of statute should be kept in mind at the time of interpretation. Dr. B. Sudhakar versus Union of India EIR 1995 Andhra Pradesh 86. Interpretation should be made in this way so that mischief may not find a place. SC Garg versus Delhi Electricity Supply Undertaking EIR 1995 Delhi 62. The words should be made meaningful with harmonious construction. Messrs. Kailash Talkies versus the State of Rajasthan EIR 1996 Rajasthan 30. When there are more than one meaning of a taxation law, then such meaning should be accepted, which is in favor of MSS Srimati Chaya Gupta versus District Registrar Chennai AIR 2004 Madras 94. When there is a saving clause in a statute, then its interpretation should be made in harmonious way by taking into consideration the whole section. PS Stapan versus Andhra Bank Limited AIR 2004 SC 5152 when there is non abstaining clause into special statutes, then the efforts should be made in such manner so that the meaning of both can be matched. If there is contradiction in the both statute, then the later should be given preference. As Sir Maruti Udyog Limited versus Ramlal AIR 2005 SC 851. In the case of State of West Bengal versus Committee for Protection of Democratic Rights AIR 2010 SC 1476, it has been held by the Supreme Court that the interpretation of constitutional provisions should be made in detail and liberally while considering changed circumstances, necessity of time and policies. In the case of Messrs. Delhi Air Services Private Limited versus State of Uttar Pradesh, AIR 2010 SC 573, it has been held by the Supreme Court that when there is a word shall is used in a substantial statute, then that will be considered as a mandatory intention of the statute. What is common? What is custom? Let's explain the essentialities of legal customs. Customs are the important source of law and justice. Let's discuss it. Customs and tradition have an important place in the judicial administration. Customs are important sources of law. Customs are the important sources of law. The customs have also played an important role in adjudication. The fact is that the fact is this that many customs have force of law. The judicial process has also affected with the customs. व्यवहारो ही भगवान धर्म स्तेना वहीयते नारद. That is the customs are certainly stronger. They are over and above the religion, according to D.F. Mutta. From amongst three important sources of Hindu law, one of them is customs and traditions. In the case of collector of Madurai versus Motu, Ramlikam 1868, 12 FIA 397, it has been propounded by the Privy Council that the clear evidence of customs and traditions will be considered more authenticated in comparison to original books of law under the Hindu law. It is not only Hindu law, but the customs and traditions have their own special place in other laws. It is assumed that the customary law is in existence in adding communities. Its definitions, the customs are defined in different manners from time to time. The customs have also been defined in theology. According to Salmon, custom is the embodiment of those principles which have commended themselves to the national conscience as principles of justice and public utility. According to Allen, custom as a legal and social phenomenon rose up partly by forces inherent in a society, forces having partly of reason and necessity, and partly of suggestion and imitation. According to Moran, custom is a series of conducts adopted commonly, as in the case of glass, there appears a way due to walking. Exactly in that way, custom is originated according to day-to-day transaction. According to Carter, uniformity of voice of person in the simple circumstances is the custom. According to Halsbury, a group pattern of habitual activity usually transmitted from one generation to another, or a practice which by long established usage has come to have the force of law, whether that rule may be adverse or inconsistent to the normal law of a country. In the case of Harprasad versus Sidwaj versus Shivdayal, it has been stated by the Privy Council that the custom is such a rule which by long established usage in a specific family or a particular region has come to have the force of law. From the above definition, it is clear that the custom is a rule which has long established usage and such usage has come to have the force of law. While explaining the essentiality of following customs in theologies, it has been stated that देही जात कुलानाम च ये धर्मा प्राग प्रवातिकाण तथैव ते पालनीया प्रजा प्रक्षुभयते अन्यथा बृहस्पति says all the customs prevailing in a caste or a family of a particular place should be followed continuously, otherwise, dissatisfaction and indignation will rise amongst person. यस्मिन् देशे च आचारो व्यवहार कुलस्थिति तथैव परिपाल्यो अशो यदा वंशानुपागत according to Yarvakalya. All on victory upon a country, it is the duty of victor that he must allow the conquered persons to follow their custom, practices, and tradition as they were continuing in the past. It is clear that the customs are essentially to follow. Not following of custom may result in disturbance and indignation. Essentialities of valid custom. Here it is to mention that neither all customs do not have the force of law, nor pursuance of them is necessary. There are some requirements of the customs having force of law as one, they should be ancient, two, they should be certain, three, they should be logical and reasonable, four, they should be continuous and peaceful usage of them, having capacity of acceptance as a right, should not be immoral and adverse to public policy, and should not be inconsistent with the statutes. One is to be ancient. The first requirement of a valid custom is that it should be ancient, that it should be. That is, it should be prevalent from all time. No date for oldness is certain in India. It is also not necessary that the custom is so old that it is out of memory of the person. Musani versus Nawab, year 1941 BC 21. In the case of Bab Narayan versus Subhasha for MIA 466, it has been held by the Sir John Rankin that although it is not necessary in India that the custom be prevalent from unknown time, but it is necessary that it has been prevailing from a long time. In the case of Maharaja Mehtaviraj government government of Bengal 1943 to SSSP 186, it has been decided that a custom which is 20 years old may be considered as a valid custom provided that nothing has been proved against it. To be certain, the second requirement of a valid custom is that it should be certain. The custom, irrespective of the matter, that it is too old. If not certain, then it cannot be a valid custom. Hence, the custom is required to be certain along with its oldness. Also, to prove it has also to prove it that the custom is old. Its certainty is too necessary. Actually, the certainty of custom proves its existence. In the case of Justice Wills Broad Band 1740 to Wills 360, this view has been expressed that a custom should necessarily be certain, because if it is not certain, then how it can shed that it is prevalent from memorable time. In the case of Guru Swami Radha versus Piru Mal, year 1926, Madras 850, the question of customary right to enjoyment of free shadow was involved. It has been held that how the custom may be in respect of shadow of trees. For certainty of a custom, its origin is first necessity. The shadow of tree is so uncertain, suspicious, and challengeable that no custom can be originated from it. According to Sir Hari Singh Gaur, the custom should be certain in three meanings: one, respect of nature; two, in respect of place or origin; and three, in respect of affected person. To be logical and reasonable, valid custom is required to be logical and reasonable. There is no standard of reasonableness of the custom. It is upon direction of the court that to which it may consider reasonably and to which or not. Generally, such custom is considered reasonably. Generally, such custom is considered reasonable, which is not adverse to public interest, is not against the public policy. Radha Verma versus Ravi Verma for IA 76 PC is not immoral. Rex versus House to Bombay HCR 124 is not unjust. Breyer versus Food 1968 LRC QB 497. If we refer the Sati Prabha, it cannot be said that reasonable as it is against the public interest and public policy was. To be used continuously and peaceful, the fourth requirement of valid custom is its use in continuity and peacefully. In other words, it can be said that the custom is being followed continuously from the date of its origin. If a custom is not being followed continuously and not being used peacefully, then it cannot be considered as a valid custom. Use of the custom without any obstacles may be said as peaceful use. Capacity to the accepted as a right. It is necessary for the valid custom that it is being used as a right. Such use should be independent and uninterpreted and not in a secret manner. Also, to follow the custom by all persons should be compulsory and not voluntarily. Salmon is of the view that the custom should be like that. There should be a concept amongst the person who use it that the custom is binding upon them and optional. Salmon also called it as the necessities, opinion necessities, not to be immoral and against public policy. It is necessary for the valid common. It is valid. It is necessary for the valid custom should that it should not be immoral and should not be against the public policy. The custom has been treated as morality. Morality means good conduct and not immoral conduct, and a conduct against the public policy. For example, such custom shall be treated immoral and against the public policy wherein The wife can quit his husband as and when she desires, or a daughter may be adopted for immoral purposes. In the case of Balu Swami versus Balakrishna year 1957, Madras 197, such a custom has been assumed immoral under which the marriage of a daughter can be made with a son. It has also been considered against the public policy, not to be inconsistent with the statutes. At the last, it is required that the custom should not be inconsistent with the statutes. It is well established that the law, the laws passed by the parliament and state legislation are supreme. The customs cannot take place of them. This is the reason that the customs are required to corresponding to the statutes. Where the contradiction appears between the customs and laws, there the laws have precedence over them. In this way, existence of all the above elements is necessary. In a valid custom, in the case of Srimati Devi versus Ram Kidan, year 1982, Allahabad 248, it has been stated by the Allahabad High Court that the custom of caste or sub-caste should necessarily be ancient, certain, reasonable, and not against the public policy. Kinds of custom. The customs are mainly of the following kinds. One is local customs. Such customs which are prevalent at a particular place are called local customs. The reason of which customs is country, state, or city. For example, custom of having more than one husband exists in Malabar. This is a local custom. The local custom is required to be reasonable, logical, certain, continuous, permanent, according to law, and non against the public policy. Local custom is offered only in a particular place or region. Persons of privilege cannot claim for local custom and at other village. Sober B versus Coleman 1867 LRX 1906. General custom, such custom which the prevalent in whole country and all the persons generally follow them are all the persons generally follow them are called general custom. Such general customs are required to be memorable. Salmon and Keaton are also of this view. Customs of a class, such customs which are prevalent in a particular class, caste or community are called customs of a class. The reason of such customs is comparable limited. Such examples of these customs are as under. One is the custom of adoption in Muslim society in a particular village or a particular community. Two is the custom of interracial marriage in Punjab. Three is the custom of not depriving of the right to succession to adoptness in the family of his father in Bajwa, Jat community of Sialkot, etc. For its small custom, family custom, such customs which are prevalent in a particular family are called family custom. Such custom is required to be proved. In the case of M. Gangama versus M.B. Naidu AR 1983 NOC 6 Andhra Pradesh, the following differences are mentioned by the Andhra Pradesh High Court. One is all the persons of relevant reason are bounded with the national custom, whereas the members of relevant family and bounded with are bounded with the family custom. Generally, the regional customs are not movable, whereas the family customs are active. That is, they move with the family. Conventional customs are also called usage. The conventional customs are based upon the conditions certainly included in the context. In the administration of a business is continuing from a long time on the basis of agreement executed between the parties and all the parties are following it, then it becomes business or commercial usage. All the elements which are necessary for hotel custom, the same are also necessary for the conventional customs. Justification. The following are the main reasons of justification of the custom in view of justice. Administration and judicial process. One is the customs are consisted of those principles which are justifiable. One is justifiable, two is logical, three is public utility, and four is favorable and favorable to national conscience. They are recognized by the courts because these rules are in practice from a long time, and due to this, these are authorized and established. Custom is to society as law is to state Salmon. The customs are helpful for the lawmakers in preparing the draft of law pattern sale. Memorable customs are like memorable customs are like a guide for the future. The customs help court in interpretation. It has been stated by the Justice Rees in the case of Rex versus Mount that where the words of act are misleading or suspicious, their help of customs may be taken for clearing the meaning. In the case of Goraham versus Bishop of Exeter 1852 MIA 402, it has been propounded by Lord Campbell that where the language of law is suspicious instead of clear, there to put a view different from the meaning expressed by the custom of same time or long time will not be justifiable. Now stress is being made for uniform civil code in place of customary personal customs of the country in the constitutional law. In the case of Muhammad Ahmad Khan versus Shahbano year 1985 SC 945, it has been recommended by the Justice Y.B. Chandrachud that uniform practice code for the Indians will be helpful to allay discrimination of caste and religion as well as will be a forward step towards welfare state. Let's discuss in brief the various forms of justice. Write a short note on the following. One is distributive justice, two is corrective justice, and three is legal justice. Justice means goodness of others. Justice may not be among us those people whose mutual relations are controlled by the law and the law exists among us and the law exists among us those persons where there is possibility of justice among them. According to Aristotle, the act of law is to differentiate the just and unjust. Aristotle has interpreted the just in the form of justified and unjustified acts. Justified acts are considered as lawful and impartial, whereas the unjustified acts as unlawful and biased. Aristotle has stated two forms of justice. One is distributive justice and two is corrective justice. Darwin versus Darwin Darwin, General Theory of Law has mentioned three forms of justice. One is commutative justice, two is distributive justice, three is legal justice. Ensured justice among us private person is called commutative justice. Opposite to this, when the position is of giving to society from the person, and then it is called legal justice. One is distributive justice. What is distributive justice? According to Aristotle, to give equal goods to equal persons and unequal goods to unequal person is the distributive justice. Aristotle, while taking the base of the principle of equality, has included distribution amongst the members of a community with equal and unequal parts of one is honor, means political cost, two is estates, three is other property proper for distribution to the community under the distributive justice. According to Aristotle, the standard of equality is quality and citizens' excellence. The base of the base of talent is the base of talent in democracy is an independent birth. Person having sympathy with oligarchy assumes the birth as a base in the state and other matters. In this way, the justice is proportionate to follow the proportion is justice and its violation is injustice. According to Darwin, various kinds of distribution which are required to be distributed from the community to its members are included in the distributive justice. Its main is to distribution of social interest. There are three elements under it. Participation in the profits of public goods across Participation in the profits of public goods arose as a result of activities of the state. Two is distribution of works and employments, and three is distribution of all kinds of contribution essential for social life. In this way, the distributive justice controls the legislative distribution of rights, powers, honors, and privileges. Professor Hart has limited the sense of distributive justice up to the cases of autocratic differentiations. According to Hart, in various experiments of consideration of justice, the direct general principle is that a person in one another's relation is entitled according to the relative situation of equality or inequality. Thus, without any graspable basis, the justifiable law will be that which considers the equal situation as equal, and the unjustice law will be that which defines the rights and duties in unequal manner. According to critics, Hart has unnecessarily embraced the concept of justice. The distributive justice is determined in different political systems by the different agencies. As distributive justice in democratic country, the legislative body is elected by the people, who is in non-democratic countries. Oligarchy council or lineal rule and says in some countries if it determined by the judiciary by using discretion. The problem of distributive justice may also arise in reference to private organizations. There is the question of determination of rate of wages and working hours, distribution of duties of citizens, And liabilities is also considered the part of justice. Baden Beamer has included the liabilities in distributive justice called to is corrective justice. According to Aristotle, the corrective justice is related to private transactions. Its main object is to establish coordination in relation between the person in the cases of contract or tort through legal treatment by giving adequate compensation or by returning stolen or the destroyed property and in unjust prosperity matters by giving order of returning and in such other similar matters by ensuring treatment corrective justice has been determined. Darwin, by giving the example of the rights to get back loan amount, loan amount by the loaner has clarified that the loaner is entitled to get back the amount of loan for the reasons that it is his own. Without considering any personal qualification, the justice is ensured. The rule of personal desire arises at the time when the conditions of person create differences in the moods. For example, injury, the severity of injury of the other person is determined according to the condition of injured person. The Aristotle had classified the corrective justice based on private transactions in two parts. One is voluntary and two is involuntary. Examples of voluntary transactions are one is to sell, give interest on loan, give loan without interest, to mortgage, to deposit on hire, etc. Examples of involuntary transactions are theft, adultery, toxicity, murder, false evidence, to abuse, abusive behavior, to destroy, etc. The corrective justice is necessary when a member of society violates the standards of distributive justice. In such condition, it becomes necessary that the person who had injured be compensated or the benefit derived illegally by a person be get back. Necessity of the corrective justice is to balance the equality. For example, all the persons have an equal right to vote. Now, it is a person is restricted to vote, then the balance will be distributed. In such cases, the balance is maintained by ordering the person for giving compensation who has stopped forcibly from the right to vote. Mainly, the corrective justice is made applicable by the court or by other governmental institution having judicial powers. Its basic reasons are one is context, two is mischief, and three is crime. The justice is assured by compensation in contract and tort in respect of the cases of civil nature and by punishment to the offender in respect of criminal cases. Baden Himmer, jurisprudence. Three is legal justice. Saint Thomas Aquinas St. Thomas Aquinas has described the imposed duties and liabilities on the person for the benefit of all society in the legal justice. Due interpretation of the concept of legal justice has been done by Jean Davin. It is differ from the distributive justice in this matter that the distributive justice provides from the society to the members, whereas the legal justice provides from the members to the society. The legal justice is an moral quality. According to Davin, the legal justice expects give from the members of the society to the community. Its object is to make legislation for group interest which may fix the duties and liabilities in favor of all society of the members. The following subjects are included in it. One is taxation, two is army service, three is participation in regional programs, and four is to follow legal and valid orders, etc. For the persons, it is not only sufficient to fulfill the duties, civil, political, and social for the state that for the state, but it is required by them that they may give their personal activities and property for the social interest. According to Davin, the legal justice is the moral requirement quality for public interest because the object is public welfare. The law and morality are so profoundly found in the legal justice that more or less they become mixed. Thank you, all my brothers and sisters, ladies and gentlemen, students, scholars, teacher, trainer, professor, professional, officer, official. I thank all my respected doctors and directors. I thank all my honorable minister and manager. I thank all my honorable advocates and administrative treasurer. I thank the honorable present Prime Minister Modi. Thank you very much. Nice to see all of you. Thank you. Tomorrow we will discuss, highlight various principles of justice in detail. Thank you.